What's the status of these cases, please, Ms.
Judge, we don't have resolution. I did file this afternoon the amended forfeiture complaint, which had two amendments. First and foremost, the state is electing to proceed against Ms. Brattset only at this time. And it also clarified in the underlying portion of the charging language the actual theory, which I think was understood to everybody all the time, but the original complaint inadvertently included both the beginning portion of the violation language in 19.96 and the second part. It was separated by an or. And so I just amended the complaint to reflect that we are proceeding on the theory that Ms. Brattset, by an act or omission, violated Wisconsin statute 19.84. And that was always clear from the probable cause portion of the complaint, but once we got down to writing jury instructions, that portion of the charging language was confusing because it included both theories upon which the state could proceed.
So you're asking me to dismiss the remaining defendants' cases?
Yes, by virtue of the amended complaint.
Any objection to that request, Mr. Yanachek?
No, Your Honor.
And you represent all four defendants?
I do.
All right, so the motion to dismiss the cases against the other defendants is granted, and that would be Lawrence Cow, William May, and Edward Miller. Those matters are dismissed without prejudice. And as to Winona Brattset, Mr. Yanachek, do you admit service and waive reading of the amended forfeiture complaint?
I do.
Service of the amended forfeiture complaint is admitted, reading is waived. So, Ms. Happ, is it your preference to go ahead and trial is scheduled on Monday of next week?
Yes.
And Mr. Yanachek, would you be ready to go to trial next week?
Yes, sir.
So the amendment and the charging language doesn't cause any notice problems for you?
It does not.
And just to clarify, either date would work for the state. I know there are two subpoenas yet out for service, both for local citizens. I don't anticipate any availability problems, but I believe Attorney Yanachek's preference was for Monday.
Is that your purpose, Mr. Yanachek?
Your Honor, I'm always interested in hearing the court's preference and availability.
It doesn't matter to me. I actually have one other case scheduled for next week, Monday and Tuesday, which would take precedence if I had to bump a case. It's a felony sexual assault case, I think, Ms. Happ. Newkirk, do you know if that matter's likely to go or settle?
I thought, Judge, that was expected to come off, so I'm surprised that it has not yet come off. Was there a final status on that file?
No, that was put over until later in the week.
Okay.
Madam Clerk, would you see when the Newkirk matter is scheduled next? It's 14 CF 418.
Set December 10th at 2:30.
Okay. So, and is that the only other case that remains on the jury trial calendar for next week, Monday and Tuesday, besides this forfeiture matter?
I think there's a TR matter, Judge, but I can tell the court from talking to the attorney there that there may be a request to adjourn the final status because there was a recent offer on the TR. It's hopeful that will resolve.
And that's the other 3 o'clock matter this afternoon?
Yes, and Attorney Johan is here.
Okay. All right, so that's a long way of answering your question, Mr. Yanachek. I stack cases as we need to do, of course, and then the more serious cases would take precedent if more than one needed to go. The state against Newkirk is a child sexual assault case. I have the lawyers coming in the day after tomorrow at 2:30 in the afternoon. The notes indicate it's expected to be a plea, and so that would remove it from the trial calendar for next week. So we should be able to let you know by Thursday at noon for sure whether you're going to go to trial next week. It's also possible that if the sexual assault case were to go ahead, they may only need one day or the other, and they may have a preference Monday or Tuesday. So it doesn't matter to me when we try them. I'll be here both days. But how about we let you know by Thursday at noon which day it'll be?
I think that would work, Your Honor. Thank you.
All right. Yes, ma'am? Something else you want to say?
I'm sorry, Your Honor, I believe I thought the final status at 2 o'clock, 2:30 on the 10th?
something else?
You said you notify them by noon on the tenth?
Oh, yes, okay. By the end of the day on the 10th, we'll notify you.
Understood.
She's right, it's an afternoon pre-trial conference, so I'll let you know by the end of the day. And if you don't hear, feel free to call us, but we'll let you know by the end of the day on Thursday. And we'll let you know then as well whether it'll be Monday or Tuesday. So if you prefer Monday, I'm happy to note that.
Today, or did you want to wait till Thursday for us to advise?
Do you have a preference you can tell me now?
I prefer Monday, Your Honor.
Okay, so we'll note that Mr. Yanchuk prefers Monday rather than Tuesday. And we'll let your office know as well, Ms. Happ, on Thursday, of course. So we have the, well, I should actually ask you this as well, Mr. Yanchuk. On the amended forfeiture complaint, you want to enter a not guilty plea on behalf of your client?
Yes, Your Honor. Not
Okay.
guilty.
Not guilty plea is received on the amended forfeiture complaint. The state has filed jury instructions today, and so has the defense. I was handed these several minutes ago. I haven't actually had time to analyze them. Do you see any significant differences in the requested jury instructions, Ms. Hamm?
I do, Judge, but Attorney Yanchuk and I sort of talked through them. So I'll defer to Attorney Yanchuk in terms of whether he has specific objections to mine. Mine does vary quite a bit from his, and most significantly with regard to paragraph 2, which actually addressed the knowingly attending a meeting held in violation, which is not the theory that the state's proceeding on. The state is proceeding on the theory that the violation was that the notice of the meeting did not set forth with sufficiency in a form really likely to apprise members of the public of its subject matter. And we've talked through that, so perhaps we could start with whether Attorney Yanchuk has objections to my proposal.
Okay, and I don't intend to make a final decision on them now. I'm simply trying to identify the issues so we can have a more intelligent discussion next week.
I'm all for that, Your Honor. I don't see any major issues with the state's proposal.
All right, so we'll make a final decision on the jury instructions next week after you both have another opportunity to make final argument. If there were significant issues, I want to identify those today and allow us all to do some research between now and next week. I feel the same on the motion in limine that's been filed by the state. If you don't see anything that's a significant controversy, I'll put off a final decision on that motion as well until next week. Mr. Yanchuk, if you see anything that's significant or likely to cause significant controversy in there?
Your Honor, with respect to motions in limine number 1 and 2, we request and move that the order apply to the state's witnesses as well, except for the presence of the court officer. We have no objection to motion 3, no objection to motion 4. With respect to number 5, we request and move the court for an order that the order apply to the state's witnesses as well. And as to number 6, there is no objection.
And Ms. Happ, do you have an objection to me granting your motion limine on the basis requested by Mr. Yanchuk that it essentially be reciprocal and apply to both parties?
Judge, intuitively, no. The only caveat or request I have is I have not yet met with Ms. Blaskowski or prepped her, and so I just want to make sure that if there were some sort of relevant dispute, that I would certainly raise that with Attorney Yanchuk, and if there was disagreement, raise that with the court prior to any testimony being taken or introducing that to the jury, because I can't think of an instance, Judge, where that wouldn't also be a reciprocal order here, but I would just like to reserve the right to raise that in advance of the jury trial, should I think that's necessary and relevant.
Okay, which paragraph would that refer to specifically?
Paragraph 5, Judge, and it basically comes down to, I can say this just because we're dealing with the jury here, that there have been prior open meetings complaints against the town, not just by Ms. Blaskowski, who's my complainant, but other issues. And to the extent, it does say town of Sullivan, I apologize, I just said town of Palmyra. To the extent that perhaps, let's say there's an argument that was introduced at trial that somehow is related to sufficiency of notice, or subject matter, or things of that nature, someone wasn't aware of obligations or what they were required to do, that somehow that might open the door perhaps on cross or in rebuttal to argue that the town or Ms. Brattset specifically was aware of that. So I just don't want to foreclose that, but I would be very sensitive to the court's order, and if I felt I was getting into anything of that nature, I would ask the court, to have the jury be taken out, so that we're not tainting our jury.
All right, Mr. Yanchek, if I grant the motion on a reciprocal basis, it would be with that caveat as to both parties. If something becomes relevant that was covered by the order on the motion eliminated during the trial, I'd always be willing to listen to a request outside the presence of the jury for an exception, so long as it was clear it was not something that could have been foreseen earlier. Is that acceptable to you?
Yes, that's understood, Your Honor.
All right, so the motion eliminated filed by the state is granted. It applies to both parties. And the court will consider exceptions to the motion eliminated, but the offering party is required to bring any such request to the attention of the court outside the presence of the jury before any such evidence is submitted in front of the jury. The exceptions of the exclusion order will be the court officer. Do you know who that will be in this hand?
That would be Detective Dan Hervada.
Okay. And Mr. Yanchek, do you have a defense investigator you'd like to have the same type of exception for?
No, Your Honor.
Okay, you pretty comfortable we can do this in one day, Ms. Ham?
Yes.
And Mr. Yanchek?
I think so too, Your Honor.
So, will this be a 12-person trial or 6-person trial, Mr. Yanchek?
6-person, Your Honor.
Paid for 6? I haven't looked at the statutes on peremptory strikes recently. Do you have an idea what that might be on a case like this, Mr. Yanchek?
No.
Ms. Ham?
I'd only be guessing, Your Honor.
That's what
That
I...
would be two. Under 97203, that I do know. Okay, here we go.
97803?
97203, it looks like,
Would we be under 805, civil trial?
I think you're right, Judge, sorry.
So it's 3, under 80508 sub 3. Did you agree to 3, Ms. Ham? Per side?
Yes.
And Mr. Yanchek?
Yes.
3 peremptory strikes per side. Is there anything else that we can accomplish today, Ms. Ham?
Just the only question that Attorney Yanchek and I had prior to court taking the bench was with regard to whether the court would want us to submit a verdict form. It seems pretty straightforward. It would be a 5-6 verdict, of course, but I don't know. We can maybe try to work out amongst ourselves.
I'd like you to try to work something out, and I will require the state of the minimum to submit one as the prosecuting entity. If you can work on one that you agree on, that's the best situation. And of course, if you can't agree, you're always free to submit your own proposal, Mr. Yanchek. So the answer is yes. And then you can bring that with you to the trial. That'll be before then.
And if we didn't know if you felt the need to use the 8:30 start date, the only reason I thought of starting at 9 was if there were any last minute pre-trial discussions or negotiations, we could maybe address that prior to the jury coming in, but I'm not sure if they've already been told to come in at 8:30.
No, the call won't actually go out, or the message won't be put on the machine until Friday at 4:30. I think know, I'm not here Friday, I have a chief judge meeting in Madison, I have a reserve judge here Friday, I don't want him to be acting on this case. I'm available by phone if it's some type of emergency, but if it's gonna be movement on settlement, I'd really like to know by the end of the day Thursday.
End of the day, Thursday.
Yes. I don't want to start at 9, if you're pretty sure we can be done by, get to the case to the jury by that afternoon.
We better be.
How many witnesses you have?
At least 4, Judge, but possibly more, but I think we only have, the defense only has 1 witness in addition to the state's list, so we might be looking at half a dozen. We're going to try to discuss whether there can be, certain stipulations related to the foundation or even perhaps hearsay that could abbreviate things and get to the legal issue.
I'd rather keep it at 8:30 for start time. If there are settlement negotiations, hopefully those are completed before the day of trial rolls around. I'd rather get started at 8:30. We have the jurors arrive at 8, they spend a half hour showing them the video and going over the basic rules with them, and so we'll have them brought in here at 8:30. We'll pick the jury and go right into the trial. Anything else today from the state,
No, thank you.
from the defense?
Oh, yeah, thank you.
Okay, you're welcome, recess.